Good evening, ladies and gentlemen. You are welcome to GHIE Chemical Mining webinar this evening. My name is Engineer Peter Adonte, and I'm your moderator for tonight. We want to welcome everybody. Before we start, we want to have a word of prayer, and we humbly ask our sister Patricia Uncle to say a word of prayer. Then we start. Thank you very much.
Okay, hello, good evening, everyone. Let's pray. Father, in the name of Jesus, we thank you for today. We thank you for bringing us this far. It's our prayer that everything that is going to be discussed here will bring a fruitful, will be fruitful in the end. In Jesus' name we pray with thanksgiving. Amen. Amen.
Amen. Amen. Thank you very much, Engineer Patricia Uncle, for the prayer. We really appreciate it. Thank you very much. You can just write something in the inbox if you are here. Thank you. All right. I firstly have to state the rules of engagement before we start. We want to ask that please mute your phone or any source of device you are using for this meeting so that it wouldn't be having any kind of infusion into this meeting. This is GHIE Chemical Mining Division. We have 5 subdivision. The chemical engineering subdivision, the mining engineering subdivision, the petroleum engineering subdivision, the petrochemical engineering subdivision, and materials engineering subdivision. So we have 5 subdivisions under the chemical mining division, and want to call on all and sundry that you can join us. If you want to join us, a number will be posted in the inbox. Then you can just contact and we take you through the process so that you become an engineer. Yeah, thank you very much. We want to move straight to today's webinar. For me, it's going to be an interesting one because personally, I have, let me say, affiliation to this discussion. Speaking to us this evening is the Deputy Chief Inspector of Mines under the Technical Service and Explosives Minerals Commission. He's a mining engineer with over 20 years of working experience. He has worked in the Inspectorate Division of the Minerals Commission in various capacity, and currently he is in charge. He's the second in charge, Deputy Chief Inspector of Mines in charge of Technical Services and Explosives. He holds a degree, Masters of Science in Mining Engineering from the University of Mines and Technology, Takwa, Ghana. He's also a former member of Australian Institute of Minerals and Mining. Over the 20 years, he has a research work over explosives, mining legislation, regulations, and compliance, environmental protection, and corporate social responsibility management. In fact, he has a rich experience and knowledge over this field. Ladies and gentlemen, it's my singular honor to invite Mr. Desmond Boahin to speak to us about what you need to know as an engineer. And it's going to be an interesting discussion. If you can show some love in the inbox with an emoji of welcoming him. So thank you very much, Mr. Desmond. Over to you, sir.
Good evening, colleagues, ladies and gentlemen, Mr. Moderator, and the MC. It's an honor to be here as well. And my senior supervisor, Dr. Bright Afum, I honor you and appreciate you for being here also. And guys, I appreciate you all. So for today, we are discussing what we need to know as engineers regarding the framework in the mining sector. I believe we have, in our various ways, dealt with mining and the associated regulations. Today, we want to take a look at a bit of where we are coming from as a nation with our laws and where we are and what we seek to do so that we can maintain safety in the mines, we can maintain efficiency, we can balance our economics, and we can be efficient in its sense, such that mining does not become a curse, but it becomes what the citizenry wants it to become. So I want to start from the fact that our constitution decided for us that with mining, we have to undertake it in a certain manner. So from 1992, when this 1992 constitution came into being, the Article 257 gave us how minerals in Ghana must be owned. And from that one, we came to the legislations where we have the Act itself, the mother of all, and we have the allies, which gives effect to this Act. From the Act, or before 2006, we have had several PNDC laws which were governing our mining industry. And I believe that if for the mining engineers over here or all of us over here, we may be conversant with the PNDC law 218, which was the small scale mining law, and then the 153, the PNDC law 1986 153. So all these ones were shelved, or to say they were discontinued, and then the Act 703 came into being in 2006. Before the PNDC laws, in 1962, we had this Act 124, where we had the Concessions Act. So before we graduated to the 1986 and 89 small-scale mining laws and then the minerals mining law, government issued a communique to all the citizenry that whoever has had any concession, whoever has had any agreement from government, you should own it, you should bring it for regularization into the new laws. So that was done. You have people who have various agreements dating back to the 1950s and all, who then were rolled over to the mining law in 1986 in the 153. So after all that, when we combined the small scale mining law and then the minerals and mining, we then came to the Act 703 in 2006, which we are using currently. With that, we have had some amendments. We have had amendment in 2010, which was mainly to the royalties under the section 25 of that act. Then we had, that was Act 794. That is the Amendment Act. Then we had the Act 900, the one that the Chinese lady was being charged under, that in 2015, we had that amendment. That amendment had the mining law, the royalty being changed, and also the offenses under the Section 99, which had to do with small-scale mining, also being changed from the main act. So these two amendments, then we came to 2019, where we wanted to stiffen the punishment under the law, and then we had the Act 995, which increase the penalties and also prescribe forfeiture of any equipment that is engaged in small-scale mining or proceeds of anything that is engaged in illegal mining. So once you undertake any illegal mining and you are caught and you are sent to court, you'll be charged under the Act 995, which is the amendment under the Act 703.
Hello, Mr. Desmond.
Yes, sir.
Sorry for just coming in. Can you share your screen with us, please?
My screen is empty. For Ejiri will tell you that I normally don't do with the slides.
Okay, then probably if you can give us a video of you, if that's okay by you.
Yes, I can.
Okay, sir.
So that we have a.
Thank you very much.
A discussion.
Thank you.
I don't know if.
Go ahead.
Yes.
Go ahead.
Good. So aside the Act 703 and its amendments, the Section 110 said that the minister must come out with legislation or the legislative instrument so that it can give effect to the act. Now, in 2012, we had the LI 2173, 2174, 2175, 2176, 2177, and then 2182. So the general regulations, the support services regulation, the compensation and resettlement, the licensing regulation, the minerals and mining, explosive regulation, and then health, safety, and technical regulations. So these regulations came into being. Then in 2020, we brought also on board the tracking regulations, which I think now you guys hear that when you are bringing in excavators or any mining equipment, you have to go to DVLA, you have to go to Ministry of Transport, and you come to the Minerals Commission such that your equipment can be tracked. It was all to, try and curb illegal mining such that every excavator in the country can be tracked wherever it's working. So your concession boundaries are geofenced, and that is where we will track you from. Aside these regulations, we have the Forestry Commissions Act, we have the Internal Revenue Act, we have the Minerals and Mineral Development Act, the Act 912. We have the Gold Board Act now, which came just this 2025, the Act 1140. All these acts seeks to give effect to our Act 703, such that mining can be efficient and can be economical to us. Now, once economy and efficiency come, we must ensure that everybody who undertakes mining goes home, comes to the mining enterprise safe and goes back home safely. So I want to just give a brief overview about the act, what its principal objectives are. So knowing that from 1962 coming through to 1989 and now the 2006, we have learned a lot of things from our neighboring countries and from the global space where mining is being undertaken. Please, it seems somebody's microphone is opened.
Doti, can you please mute yourself?
Good. So the Act 703 to consult
This one, you are on mute, please unmute yourself. Sorry. Yeah.
Okay, good. Is it fine now?
Yes.
Good. So the Act 703 came with certain provisions such that investors from the diaspora and will bring their money. It was to ensure foreign direct investment. So there were certain key provisions that ensured that all investors are secured or their investments are secured. There is a provision called or a provision under the section 48 and 49, what we call the Stability Agreement and Development Agreement. This Stability Agreement seeks to protect all investors from all shocks that may come down for 15 years after the issuance of all these licenses that we get, especially when it is for exploitation, that is the mining leases. So anybody who has a mining lease, the government signs an agreement with you when you have satisfied the development agreement. The development agreement works this way. You have to, from the time of your reconnaissance where you started looking for the mineral to the time of exploitation, you must spend an amount of $500 million. So there is a provision, capitalization of expenditure under the 28, whereby all the investment that you have done down the line, it's accredited to you as money put into the business. So if that amounts to 500 million, government will, or the minister on behalf of the state will sign a development agreement with you. And I believe that you guys heard of Gold Fields Development Agreement way back in the 2014, 2015, where they had to construct Tarkwa to Daman Road for them to have a development agreement, because they needed that amount of money to be invested to reach that amount that is required to have the agreement signed for them. Once you sign that agreement, the Section 29 also have additional benefits for all mineral or all mining lease holders, whereby your taxes, your excise and your excise duties, and some payment of royalties and other taxes are protected. So let's say that you sign an agreement today, the royalty rate, the income tax rate, all the taxes that are in force is what's going to pertain for the 15 years that you will be doing the mining. It is subject to renewal. You can renew, and you have to demonstrate that, yes, you still have that much of investment in Ghana to have it done. People have a problem with this stability agreement because they think we are losing. It's a form of hedging and it doesn't help. But fine, it may have lost its value, but as of the time that it was coming in, it actually pulled a lot of investment into the country. And that is what the Gold Fields and then the Newmonts were not. You don't have a lot of companies with development agreements, so to speak. Gold Fields and Newmont and Anglo Gold, they are the ones that had that much of investment, and therefore they have enjoyed that for the years that they signed onto it. These agreements that we have, once you have a license in place, or once the government issue with a license, you now own the mineral on behalf of the state, and you are supposed to work it out to benefit the state. So when you look at our general regulation, the LI 2173, the regulation 7, it requires that in the exploitation of your mineral resources, you must ensure that there is due diligence, there is economy, there is health and safety, and there is efficiency. These four. And also under the Act 703, the Section 105, you must also prefer Ghanaian goods to all other goods from anywhere. It is only when you don't have it from here that you will choose. But in doing so, the provision prescribes that it must be done under economy, efficiency, and then safety. So if you are going to buy anything, from Ghana for the purposes of mineral operations, yes, you must ensure these three things. But the key thing is that if it is not safe, if that product you are buying, it's not safe by value, if the person you want to employ as a Ghanaian will not be able to work safely or does not have that expertise or competence to work safely, then you are not, by prescription, not obliged. So you must take that into consideration, that it is not that because the resource belongs to Ghana, you can just, we can push anything into the business or bring on board Ghanaians who are not qualified. So once you have your mining lease, the first and foremost, the Section 16 is saying that you must employ a person who has the requisite qualification and experience. So the mineral right holder or the owners of the mine must employ persons who have the ability or who have the right competence to manage the mine. That takes us into the regulation, the LI 2182, that the regulation 33 and the 34 ensures that we must bring on board competent managers or manager of the mine who is competent, and we must ensure at all times that there is a manager in charge. Why? Because you cannot leave the operations to any person who is not qualified to manage the mine. So who then is qualified to manage the mine? The regulation 37 has prescribed for us what the qualifications of managers of a mine is. And when you go to for every legislation, when you go to the back, you have the interpretation or what we call the glossary. So the regulation 560 of the 2182 and then the section 111 of the act have some interpretation. Under the 2182, the page 312 define for us who is a competent person. So this competent person who is appointed in terms of the regulation to manage the mine, you have his qualification under the regulation 37, and you have the interpretation of manager of the mine on page 316. I know it's a contentious issue when it comes to engineers in this regard, but I will implore all of you to put these provisions and these pages that I'm calling down so that you can go and read under the manager of the mine under page 316 and also the regulation 316. Yes, sir. Sorry, guys. Somebody botching tomorrow. So under the page 33, regulation 33 and 34, you take your time and read it. If there are questions, we can further discuss them. Now, when you are appointed as the manager of the mine is in your hands. And the regulation 44 requires that you appoint other persons or other managers and other persons to manage the whole mine. So when we come to the general administration of the mine, when we come to the process plants, when we come to ventilation, when we come to the TSF on the mine, when we come to the workshops, we must have other competent persons to manage the mine. In this way, these persons are also supposed to be competent. And that prescription that the page 312, or that description or that definition that the interpretation gave for competence person applied to them. So a person who by his training, by his knowledge, by his experience, and by his skill can organize the work in a manner that is safe and can avoid danger to himself and all other persons that he's working with. So supervisors are to be appointed, line managers are to be appointed, and then they report through the command chain to the manager to ensure that the mine is worked efficiently, safely, and economically. Why do we need a competent person? If we don't put competent person in charge of operations, if the person who is doing the job, like an operator, like a line manager, like a TSF attendant, if you don't have these persons to be competent, then any accident that occurs on the mine, the manager must show that he took proper precautions. Now, for a manager to show proper precautions, that he put the necessary things in place to avoid danger to persons, such that you avoid incidents, he must go through a whole lot, which I will take you through a few. As an engineer, you know that a machine has its own risk. You might carry out your own risk assessment, and you must have your own procedures to it. But the person who is coming to do the job, or who is coming to handle that equipment, is he trained on it? So the manager must then come out with his procedures. He must come out with what? His training models. So the regulations, both the explosive regulation and then the LI 2182 have the codes of safe working practice, or this SOPs. So the regulation 11 of the 2177, the regulation 287 of the 2182, and then the regulation 515 of the same 2182 gives to us our codes of safe working practice. So the codes of safe working practice will look at the job schedule, where the job will be done, the persons that are involved, the various risks that are involved in that work, and then a thorough risk assessment can be carried out. Then upon that one, we can now generate our training model. Once we generate that training model, a competent person, as prescribed under the regulation 547, is to handle this training, not HR. HR can coordinate the training, and then we, the engineers, knowing how we interact with the machine, knowing the design of the facility that we are in with, whether it is the plant, whether it is the TSF, whether it is an embankment, whether it's a dam, whatever it is, geotechnically or in the its management sense, we know what to do. HR might not know. We need to prescribe what the training models are, and then we train persons on. Once we train the persons on, then the person can be put under a competency certification. So the Chief Inspector of Mines certify all personnel in mining. So once under the regulation 97, an operator is certified. Under the regulation 44, you have to certify all persons. Under the regulation 50, 51, 52 to the 54, we have the inspecting engineers, we have the sectional engineers, we have the resident engineers, and then the 288, the engineering manager. Once we have these persons, various duties are assigned to them. Once you assign the duties to them, then under the 290 and 291 of the 2182, the job is handed over to a competent engineer, and continuous supervision is required. The same way when it comes to the mining side, the regulation 36, 37, underground and then surface, we have the qualification of the managers, as I said, together with the mine captains. And then the regulation 45, we have the qualifications of all mining foremen, and duties are assigned to them under the regulation 47. So once those duties are assigned to you by your training and by your job description, you know what to do to ensure that the job is done safely. If you don't do that and there is any accident, the regulation 18 requires that the competent person must come and show cause why his certificate should not be revoked or cancelled. What that means is that once you are certified and you have certificate of competency, it is required of you that at all times you show competence and you do the job safely and you avoid danger to yourself and all other persons that you work with. If you don't do that, the regulation 41 will not apply where the manager is the one to show cause, because here the manager has certified you and you have your certificate of competency. Therefore, you must supervise the job or you must undertake the job that has been assigned to you safely to make sure that the material or the gold that we require, the manganese that we require, the bauxite that we require comes to us without anybody's blood. If you don't do that, then you will be charged under the regulation. Where you are found culpable or where you are found to have contravened the regulation leading to any incident or accident, you, that employee, is the one to be charged. The manager would then have exonerated himself. So under each training records must be kept. Training records must be kept. And these training records, the inspectors of mines must continually check that men and women or workmen are always trained in accordance with the risk involved in their work. So somebody who is working in the plant or in a hot area or in the pit, we have a different training program from the person who is working at the TSF. A person working at the TSF has the risk of what? Drowning. Therefore, the regulation 113, whereby we protect all water bodies or anywhere that a person can drown, that person would have been trained on all models regarding protection of water bodies or dams or anywhere that a person can drown. So training is key to engineers. Without training, you don't put any person to any duty. If you do that, you are telling yourself that you want somebody's hand to be severed, you want somebody's limb to be severed, you want somebody to have a back injury or neck injury or head injury. Therefore, to avoid injuries, we must ensure that men are properly trained on the codes of safe working practices of every work that they do. Once we do the work safely, we are assured that we have the work in a manner in which the regulations have prescribed. If we don't go by what the regulations prescribe, an inspector of mines coming to the mine should be able to either give you a prohibition notice to improve on the safety, to improve on the environmental aspect of it, or to improve on the efficiency of the job. Especially when it has to do with the safety of the job, we are looking at life of men. Life of men. So any supervisor, any line manager must ensure that the prescriptions of the regulation, which is the minimum, is always complied with. Aside that, any best practice that is put in place to ensure that men are safe is followed at all times. If you fail to do that, what you are telling your supervisor or what you are telling the managers is that you are not competent to handle the duties that have been given to you. Managers or engineers, what our duties are always is design and implementation. So when we take mining engineers, we are looking at our pit and the pit configuration, how it's going to give us maximum output or maximum ore. When we take the our mineral engineers, they are looking at the ore that is coming, the feed, and how much we should draw from it, given our blend. So there is a design for them to follow. If you are following that design, you must make sure that you don't follow with the blood of men. Safety, some of us will say, is a culture of men. If it is not your culture, will you follow? No, because Ghanaians have their culture, Americans have their culture. So if safety is the culture of every industry, then we have no business in saying that, no, as for that safety culture, we cannot follow. Every mine or the industry that we are in, we always want to make sure that we avoid injuries, we avoid fatalities. Therefore, from our risk profiling, what we should do is that we should make sure that we eliminate all hazard, we substitute them, we use engineering design to take care of them, or administrative procedures to ensure that men are not, injured in any way or form. When we cannot do that, or when at a minimum these things may not be feasible, that is where we have to resort to what? PPEs. But these days, we are always only talking about PPEs when we are talking about mine safety. But it shouldn't be. The hierarchy must follow, and then the minimum one, the PPE, must come. So the regulation 543, actually, it's saying we should provide PPEs for men, and the manager must provide PPEs, and the manager must make sure that the men who are provided with it use them. Therefore, you don't sit down for the person to get hurt and you said, I gave you the PPE, you didn't use. As an engineer supervisor, it is your obligation to ensure that the man entering that working area is dressed appropriately. If he doesn't have the required PPEs, he will not enter the place. Are we okay? Now, for incidents and accidents, it is not only the risk in the job that gives us the accident and incident. If you look at some of the accident models, you realize that the knowledge of the person involved in the accident played a key role. So what the person knows and what the person doesn't know will always play a major part in the accident causation. So as a supervisor, as an engineer, you must always prep your men with the knowledge that they require to ensure that they don't do things that they don't know, or they use their knowledge to affect the job positively. When we have taken time to draw up procedures, we don't leave it to the supervisor's hand to say these are the procedures. Please, am I on?
Yes.
Hello?
Yes,
Please, you are on.
Okay. I forgot to ask the moderator whether you want people to be asking questions as we move, or when we're done with all.
When you are done, then we have some minutes for question time and answers.
Okay. All right. Do I have unlimited time, or I have?
I'll send it to you. I'll send it to your inbox. However, if you have any question, you can please also write it in the inbox. Thank you. Please go ahead.
Okay. All right. So you don't leave training to supervisors. There should be a coordinated training program to enrich the knowledge of all workforce. Because without that, even imagine that somebody goes to add water instead of doing acid to water, he does it the other way, and then he splash with acid. So the knowledge of men contributes to a lot of the accidents that we have. If you have had chance in investigating accident, you will bear with me what I'm saying. So the regulation that we have has prescribed a lot of things for us in the mechanical sense, in the electrical sense, in the mining sense, in the mine management sense. But all in all, we say that managers are always in charge, or the managers are always accountable. Therefore, our knowledge as engineers, because the engineers, we become the managers and the managers of the mine, very important to ensure that the workforce undertake the job in a safe manner. I want to touch a little on the licensing, because I've gone into the regulation bit. When we want to, before anybody will be issued with a license, we have all the licenses are called mineral rights. So small scale mining license, our exploration license being the prospecting license, the reconnaissance license, and our quarry licenses are all licenses. But the mining lease, all right, or the restricted mining lease, when we say restricted mining lease, it has to do with all the industrial minerals, the granites, the limestone, the clay, sand, gravel, talc, and all those that are defined under the interpretation 111 as restricted or industrial minerals. Once you apply for any license, the Section 11 requires that you bring out some 4 key items. And 2 of the key items is the technical personnel available to you, and then the financial strength of the company, or the financial resources available to you as a company. With these 2, then you will show that this is how I'm going to do the job. So your program of work, which translates into the LI 2182, the Regulation 8, that you present an operating plan. So this work program under the 36, when it has to do with prospecting, and then when it has to do with mining, you have to have the operating plan to submit for your permit. You have to have your work program to submit for your license. Once you produce this to the commission, your license is premised on what you have presented. The feasibility studies, or your business plan, which is your program of work, when it's studied, the commission will tell you whether we have comments or we have queries for you to answer. Once you bring this, the company, the bank that you put there that you'll be routing your money through is written to, and this bank is to show that indeed you have the money, or you have the resources, whether by credit or by equity, whatever it is, to be able to undertake that mining program that you are coming to do. When it is handed, everything is through, you will sign your license. The license is sent to the minister, and the minister will append his signature and send to you. When it's sent to you, you will validate them at the High or Supreme Court, and then at the Lands Commission, the valuation. So the mineral property will be valued. You will pay the appropriate fee for that, and it's stamped. Once that is done, you do limited number of copies, and those copies will now be sent to Minerals Commission for distribution to all the relevant agencies, EPA, EPA, the local assemblies, the Finance Ministry, the Forestry Commission, all other agencies that require to be or are stakeholders of this mining enterprise are put together. So our traditional authorities, they are key stakeholders. And here, let me mention that you realize day in and out, the chiefs are saying that we don't involve them in this our licensing process. It's so to speak, it's not true that we don't involve them. We involve them very much. If you look at the section 13, the grant of license, you realize that before the minister will make that determination, a letter or a notice is sent to the relevant district assembly. So in the licensing regulation, the regulation 10, the regulation 94, and regulation 177, all details this or gives affirmation to this section 13 sub 2, where the chiefs and then the particular locality is informed that yes, this mineral property or this person is asking for a license over this land. If you have any permit, if you have any interest in this area, you should come out with it. In time past, EPA used to call that letter no objection letter. So the assembly will issue a letter after consulting all these institutions and then the local authorities, that is the chiefs and then the people, landowners, all that. And then they will put in a report and send to the Minerals Commission. You have to take a copy of that letter and send to the EPA, and that is what they will use to process your environmental permit. So you look at the section 18, that there is a forestry and then environmental protection. Therefore, once you are given the license, you are to see before commencement of your operation. If you are in forest reserve, you have to go to the Forestry Commission for entry permit, and then you have to go to the EPA for your environmental permit. And then the section 17 also requires that you have to see Water Resources Commission to take permit from them for water abstraction or adduction for use in your operation. If you don't do that, it's a breach. And of course, you have to bring that one under the regulation 8 as part of your operating plan to obtain your permit. Why? Because the section 13 sub 10 says that when you are issued with a permit, a license, you must see the chief inspector of mines for permit to issue you with permission to undertake or destroy any mineral thereof. Therefore, you must apply for permit. The small scale mining under the regulation 472 of the LI 2182 are also to apply for a permit. All right. And when they have to use explosive, this one, listen carefully, the explosive bit, for small scale mine, if they have to use explosives, the section 95 of the act requires that they apply to the Minister of Land and Natural Resources for that permit. Then the minister will route it to the commission for a permit to be issued. And there's a process to go through when they are coming for that permit. So for mercury, the section 96 also requires that they have to apply for a permit to use mercury. And when you take the regulation 473 of the 2182, it also specifies what they must do to get the permit for mercury. You don't use mercury when the chief inspector of mine have not given you permit. So anybody who does that is a breach, and you can be fined. So these stakeholders, the EPA, Water Resource Commission, Lands Commission, our courts system, the valuation, and our ministry, we collaborate to issue licenses and permits for the exploitation of mineral resources in Ghana. And I have already indicated to you, all of us, that when the license is issued to you, you must work it efficiently, diligently, and safely and economically. You don't do what we call wasteful mining. A lot of the small scale mining that is going on, or the illegal mining, they are doing wasteful mining. They mine such that a lot more of the mineral of interest goes to waste without recovering them. That's why sometimes you see, for those of us who have been to Galamsey site or to Way, they say some people are doing koli. They go behind those who have worked there already to be picking up, the material and washing and still getting some, meaning that the methods that they have used were not that efficient as the regulation requires. So for our stakeholders, we as engineers, when we are into any mining enterprise, we must know that the community also become our stakeholder, such that whatever we do, our primary impact communities receive the impact. Therefore, we must make sure that we lessen their impact. We bring down pollution. If we cannot mitigate or we cannot deal with it in a manner that is acceptable by regulation, then that community, by the 2175, the LI 2175, we must resettle them. So the resettlement and compensation regulation requires that every mineral right that is issued, first and foremost, we must look at the value of the land that the person who holds the surface right. So the Section 72, the surface right, it belongs to somebody. The land does not belong to you, so it belongs to somebody. So therefore, if that person is going to be affected or be deprived of what he requires, his interest in that land is not going to materialize anymore. Therefore, you must pay that person off, or you must compensate him for that deprivation. And if he has any crop or any immovable object or facilities on that concession or on that land, you must also pay for it. However, the regulation 1(8) of the compensation regulation requires that anybody who undertakes speculative activity shall not be paid compensation. I understand that our time is up. I will invite questions. There is a mouthful that we will have to do, but with the time constraint, we can't do all. But I believe that your questions will generate that force. So, Mr. Adontin, please, I hand over to you.
Thank you very much. Thank you very much, Mr. Desmond Boahen. Indeed, we've learned a lot. In fact, for me personally, I've even just got to know HR is not supposed to be handling training, technically. And I think there's a lot we've all learned. Firstly, we want to observe protocol. There have been some mine managers and some other big people in the business of mining on the page. We want to say welcome, thank you for joining. So we want to have the question time. You can lift up your hand up, you can show it on the screen, and we will call you. But we will start with the question on the inbox. The question says that, are the regulations primarily focused on established mines, or do they also effectively address the issue of illegal mining activities, such as those often seen along our highways? So, Mr. Boahen, we want to know, it looks like the regulation seems to look more on the mining established ones, the big companies. Are there any regulations or some, towards the illegal activities?
Thank you. So, the Section 9 of the Act says that all mineral activities require a mineral right. what that means is that if you don't take any of those mineral rights, so to speak, the reconnaissance, the prospecting, and then the mining lease or the restricted mining lease, if you don't take any of it and you undertake any of those, activities, whether looking for the mineral or in its exploitation, as we see in the illegal mining, it is a breach of law. Now, under the Act 703, the Section 81 to 99 deals with small-scale mining, and they start with qualification, who qualifies to be issued a small-scale mining license. So it's not only to the large scale, it has to do with the small scale.
Thank you. The second question says that with some of the punitive measures, some of the, in the regulations, sometimes there's some punitive measure where somebody has to pay a specific penalty. Sometimes people think the quantification of the penalty is something people can work around it. It's not that huge, and hence they may have their way out. Please, how true is it?
When you look at the Act 995, predominantly it was to stiffen the penalties for persons involved in illegal mining. When you take the Section 99, which was amended, the penalties that were prescribed there, very low. Now, under the 900, we came to 3,000 penalty units. That here, under the 995, we toughen it up and say that you go to prison for 25 years or 15,000 penalty units. So that is huge. Now, for the mining, our normal, large-scale mines, they know that even where a penalty is not prescribed for a particular offense under the regulation 56, the general penalty applies, and you can pay as much as 10,000 USD. When you come to the Act itself, you see that it also has a general penalty under the Section 108, and then you have various specific offenses under the Section 106. Same way, under the 2182, there are specific offenses, especially when it has to do with the duties of workmen under the regulation 550 to 559. If you fail to do something on the mine that secures your own safety and the safety of others, it becomes an act which is prejudicial to safety, and you can be charged 500 penalty units or 3 years of imprisonment, or to both. When you fail to follow an instruction lawfully given by your supervisor, you realize that the 552 also makes that one offense. So there are specific offenses that are in the regulation. Depending on what you do, we will find something for you. And this one, with all due respect and with all protocol observed, let me use it the way that we say it. We say you can even be fined for shitting on the mine. So the regulation 516 of the LI 2182 requires that amenities must be provided on the mine, and any person who fails to use that facility, all right, so it puts it this way, regulation 516 sub-regulation 6, it says that you it's an offense to let me put it in perspective proper. If you fail to use a sanitary facility, or if you disuse a sanitary facility, you will pay a penalty, or it's an offense to not to use a sanitary facility. If you, I want to catch the word. If you defecate on the mine, yes, it's an offense. And if you fail to use a sanitary facility, it's also an offense. So you don't have any excuse on the mine to say that I will not provide toilet for my persons. So for offenses, there are prescriptions for a lot of penalties.
Thank you very much, Mr. Boahin. For offenses, there comes with its specific penalty. So my next question here has got to do with somebody asking, I have a large acre of land full of sand. Can I go ahead and win sand for building purposes? Or I need permit? What is the process involved? Mr. Boahin, please, can you unmute?
The section 80 of the Act gives special right for owners of land. So where you have to mine an industrial mineral, which sand is one of them, for building purposes or for road purposes, you don't need a license from the minister. You can go ahead and use it, but you cannot commercialize it. So section 80 answers your question, please.
So commercializing mean not for sale. I mean,
yeah, not for sale.
With
yes,
the sand, but I can sell it.
Yeah.
Okay. Thank you. I hope the question is answered. Thank you so much. We go to our next question. He says that I have been working for small-scale mines for over 7 years. Safety is very poor, and individuals who tend to complain and insist the right thing is done, these people tend to lose their jobs. What does the commission has in place to protect these individuals?
Okay, thank you. So, under the section 90, the establishment of the small-scale mines, you have a district officer who is to monitor the activities of the small-scale miners. And then the section 92 requires that a mining committee is to be put together and inaugurated by the minister, where the district chief executive of the particular locality or district where the mining district is within chairs that mining committee. The mining committee has EPA, the Water Resource Commission, the commander, the police commander around. It has a lot of, persons to help the district officer to exercise his duties. When it comes to the regulation 477 of the 2182, the inspectors of mines are also to periodically inspect the operations of the small-scale mine. Therefore, the safety of all workmen in that small-scale mining company must be ensured by this monitoring from the small-scale district office and then the inspectors of mines. The irony of the whole thing now is that most of the time, these small-scale mining companies, they have allegiance with some people. When you go and you want to give them prohibition notice, the prohibition notice will mean that they have to stop because they are not conforming with the regulation. So the regulation 22 has 3 prescriptions. When you are contravening the regulation, when you have contravened the regulation, or when you are using a practice that is dangerous, that activity must stop. So in the regulation, the Form 1 of the first schedule requires that the inspector of mines will give you a form, will fill that form and give you to sign that you stop the operation. In the same way, under the powers of inspectors, for the engineers who are under, who are also part of the factory inspectorate, or who has, there are some powers of inspectors. The mining companies also know that there are some powers of inspectors. So under the regulation 2, where we have the powers of inspectors, it actually It's part of the function of the inspectorate. The regulation 2, the sub 5, requires that when the inspector finds that the part of the mine is dangerous or is not safe, or an equipment that is being used is not safe, the inspector has the power to use that Form 1 to seize that operation. And if the inspector seizes the operation under this condition, and the manager or the owner of that company fails to do that, the sub-regulation 7 applies, whereby a fine of 25 years of imprisonment or 15,000 penalty units is preferred against that person. So we shouldn't have this situation. But I'm telling you, and it's a fact, that you stop their operation and you have, let me use the word they normally use, powers that be or order from above coming against you. Otherwise, you see, the mining companies, when we give them instructions, they follow. They don't go telling any powers that be that, oh, this guy wants to stop. They will stop and fix it because they know the value of human life. But these small-scale miners, sorry to say, many of them, they just want their money and not the health and safety of persons or even the environment.
Oh, Mr. Boy, this really means it looks like the small scale mining even have more powers than established mines. Just as you are saying, those from above can come in. But nevertheless, I think we will relook at this case again. Before
They don't have powers. They are assuming.
Oh,
They are
okay.
assuming the powers. Yeah, because I'm saying that because you see, if any regime comes and he says that we are going to establish the rule of law, nobody is above the law, let's go by the precepts that we have, where would they stand? You would have been used to calling people to stop people from, taking actions. That action will not be there.
It is well.
Okay. It is well.
Engineer Ruth Mens has the hands up. If you want to ask Mr. Boahin any question, you can lift your hands up and we'll call you. After Engineer Ruth, we take the next questions.
Thank you very much. Thank you very much, Mr. Boahin. Engineer Boahin, very good work and presentation. But I want to ask, you see these chamfines that the Chinese people are using, they don't bring it in full. They actually bring the metals in and then they will come and mold it here. And then you see it in their shops, especially when you are in Takwa. So when you are driving on the road, you see them in their shops and other things. Can we also tackle them in their shops, because they are the producers of this chamfine? They don't import it in full. They get to Ghana, get a welder to weld most of these chamfines and all that we see on the rivers for them. Can we tackle them in their shops to also bring down the number of chamfines which are being produced in the country and going directly onto our waters to store the water? Is there anything we can, just like now excavators, before you bring in an excavator, the permitting issues that you have to go through, the permitting process, is there something we can also do when it comes to these Chinese people and the chamfines they are selling? Thank you.
Thank you, Boogie. To every law, there are gray areas, or to every legislation. Sometimes you can have circumstantial evidence to, charge people. In the case of chamfine and apparatus using small-scale mining, using illegal mining, the irony is that it's the same things that our small-scale guys use. So if you go to their shop and they say that we don't sell illegal miners, we are only selling to small-scale miners, it will be for him to prove that, okay, show me the small-scale mining company that you have sold to. At the time that the equipment sits with him in his store, the equipment has not committed any crime, or has it been involved in any crime. Therefore, under the LI 2404 and then the Act 995, any equipment that is seized from any illegal mining site or has been used to commit any illegal mining activity, that one is seized, and then the minister will take it to the court for it to be confiscated. So the police will do that on behalf of the minister, and then it's given to the state. The equipment is given to the state. So it's a gray area, just like excavator. If the excavator is sitting somewhere for hiring, you can say that I'm hiring it to construction engineers. I'm not hiring it to small-scale miners until you intercept it at the site or you find it committing the act. It becomes very difficult in apprehending anybody in his store. You know that those things can also be used as hammer nail, as a nail, right? So it's difficult until they take it there. Getting them becomes an issue unless we come out with a legislation that criminalizes people from producing such thing because it is found to be used in this one. Then the small scale people will contend, how do we do our work now? So it's a gray area, my dear.
Thank you very much, Mr. Boahin. Engineer Ruthmans, I hope you're okay.
Yes, I'm very much okay.
Thank you. So Deborah wants to know, in case where the farmer or the landowner refuses any compensation for the area or concession of interest, what can one do?
Okay, so the section 13, the grant of license, the subsection 9 provides that the license issued by the minister is sufficient authority for the person or for the holder to enter the land in respect of the mineral in which he has applied for. Therefore, there is a premise. The premise is subject to compensation, subject to section 73 and 74, a license issued by. So now that subject 73 and 74 is compensation and compensation principle. The person must satisfy the compensation of whatever that is on the land and the land before he enters the land or before he has authority over the land. If the person who owns the land, who holds the surface right, is refusing, he must have tangible reason for not refusing, because the exploitation of the mineral is in the interest of the state. Therefore, in a worst case, it will go to court, and there has been a ruling where the judge ruled in favor of the mineral right holder that the state has given the person the right to enter the land. That is the court ruling. I've always seek the interpretation for that subject to the compensation and compensation principle. So the word there is if the person is unreasonably, withholding. Now, what is the reason for the person saying I will not allow you to? Is it that you are not being paid a fair compensation for whatever it is, or it is that you just simply don't want the mining at your end? The mining is not your preset. The mining is for the state. Anybody who has been given a license has an agreement with the state to go and mine. And the thing is that when the license is to be issued, the communication that goes on, you are supposed to have shown your interest in the land before the minister issued you don't sit there for the license to be issued before you come and say, no, I don't agree. Of course, the section 2 has compulsory acquisition. Say where the mineral is for the benefit of the state, by an executive instrument, government can, or the president can have the place acquired for exploitation. So Sometimes, good. Sometimes it's not in your best interest as a landowner to refuse the compensation. When it comes critical, an order will be given and then the money will be set aside. They will mine it until you want to take your money.
Okay, thank you very much. For sometimes that factor, I really appreciate that. So we take our last 3 questions and we are good to go. Does the regulation address the proper closure and reclamation of a mine? And is there a financial assurance mechanism in place for government or municipality to close mine using accrued funds from the FA mechanism in the case permittee default or files for bankruptcy?
Okay, thank you. So when it comes to closure of mining facilities or the entire mine, the regulation 274 to 286 are prescribed for us what we need to do to close a mine. However, before you will be given a permit to start the operation, under your operating plan, under the sub-regulation 9, under the regulation 9 of the content of operating plan, you are to prescribe to us, taking into consideration the 274 to 286, the design of the whole landform when you are not there, the measures you will put in place to protect the land in the long term, how you close each and every facility that you raise on the mine. So for explosive, for plants, for pits, for adits and underground shafts, for all equipment on the mine, you must show in detail how you remove them, all region, how you decontaminate the ground where you were doing your chemical activities, everything that there is that was not there, how you are going to take care of it when you were not there. So you see that the 9, the paragraph K, requires that your reclamation plan as it is, together with the cost, because you have to know how much of soil you will need to recover the land, how much fertilizer you will need, how much of seedlings you will need to bring back or to restore the land. So yes, the regulation provides for a lot. And when you go into the section 18 where it talks about the forestry and the environmental protection, when you go to EPA, that is where they will also make you sign a bond such that you pay some monies for the eventual restoration or reclamation of the land.
Okay, so I'll just fuse in these 2 questions, then we'll take the last one and we are good to go. So Nelson is saying, I want to know from LI 2182 regulation 37, one must hold diploma in mining or metallurgy before that person can sit for the pit superintendent or underground manager certificate. I heard that if your first degree is not mining engineering, but even have masters in mining, you cannot partake in the exams. Please, how true is this? And just to add up, the other question is, every worker in the mine has to be certified by Minerals Commission, be it an operator or whoever. How true is it, and how can one get
It's not. Okay, good. So the last one first. It's not every worker in the mine who is to be certified in the mine. No HR person or security person is certified, but they work in the mine, right? Hitherto, surveyors and geologists were also not certified, but they are in the mine. So the mine management aspect of the whole thing had to do with the mining engineers, the metallurgists, the electrical and mechanical engineers. Now we have technicians also coming through. They are introducing the survey and geology as well, because mining starts with survey. We survey the land, we look for the mineral, that is geology, and then we mine, that is mining engineering. We process, that is minerals and minerals engineering, materials engineering, and the chemical engineers, they also come to, and all the infrastructure that are on the mine, the electrical and mechanical guys also take care of. So it's a multifaceted thing. And these ones where the risks are high, yes, you have men to be certified. All operators on the mine, that one, the regulation prescribed that. You can look at the regulation 97 of the 2182. You can look at the regulation 465, you sub 3. You will see that all the operators on the mine are to be certified. Excavator, dozer, dump trucks, graders, all of them. You need men to be certified, to be competent. And that's what I mentioned, that under the regulation 41, if men who are, employed in dangerous works are not certified, okay, let's say that attendants may not, a conveyor attendant may not be certified. But if he is to be secured, or if he is to be safe, the manager must take all precautions. And I mentioned that the precaution is doing the risk assessment, taking your course of safe working practice, and doing your training, providing the PPEs, making sure that all hazards and risks involved in the mine are known by the supervisor. A supervisor must be certified. He must know what there is. And when you look at the regulation 47, the duties of the supervisors, you realize that the sub 5 requires that they must always establish the level of risk, the level of dust, the level of ventilation on the mine. Hello. So it's not wholly true that everybody else must be certified, but a good number, yes, as prescribed by the regulations.
Okay.
Under the regulation 37, the prescription that has been given, it's saying that the person must hold diploma or degree in mining engineering or metallurgy or its equivalent. The issue of holding the MSc in mining or PGD in mining, where you are not allowed, it is not wholly the case. There are some people who were trained surveyors or who had first degree in survey, but when they went to the mine, they started working as planning engineers, or they started working as supervisors in the pit. So their whole life they didn't even practice the survey or practice whatever that they took knowledge in. But when you look at the definition that I mentioned under the page 312 of the competent person, the person who by his knowledge, by his skill, by his training, and by experience. So these 4 things should come. You don't expect that somebody will be working as a mechanical engineer for 20 years. He will go and do PGD mining or MSc mining, and overnight becomes a mining engineer. Trust me, that doesn't work. But if that person has been working as a mining engineer, even though he's a mechanical engineer, but then in his life, by his training and experience, he has been a mining engineer. When he goes to do that, that's why all applications for certificate of competency come with a CV for the Chief Inspector of Mines to assess whether the person is qualified.
By knowledge, skill, training, experience, that comes with competency for the engineer.
Yeah. So if sorry to cut you, if you read the regulation 21 of the LI 2177, the sub regulation 12, it says that the commission in examining the candidate or the employee shall consider his experience and his training, his knowledge and experience. So knowledge and experience is key. That's why the section 16 says that the owner of the mine, the manager that he appoints, must have requisite qualification and experience. And that qualification shows your knowledge, shows how you have been trained and your experience.
All right. Thank you very much. We take a last one. Looking at the method for mechanized mining process to extract gold, why can't TSF facility be introduced into the small-scale mining process to eliminate this pollution into our water bodies? It's not going to be a good contest for mine engineers to be affiliated to these small-scale mining to monitor and control their activities through education supervision.
We have not barred any small-scale mining to construct a dam. Of course, it is encouraged. And if you look at the LI 2182, when you look at the regulation 476, machinery in small-scale mining, it says that with the necessary modification, regulation, all equipment in the mining sector applies. So he said, with the necessary modification, regulation 287 to 486 applies. So what we are trying to say is that you can modify any equipment that is being used in the mining industry to have, we say. Now, when we are giving you the permit under the 472, you are to bring your plan, and that plan must have the TSF, a well-engineered TSF. But like I'm saying, you stop the operation and you have somebody to contend with.
Wow, interesting.
Yeah,
very, very interesting.
The mining engineer, if we have some mining engineers here, for them, they know what I'm saying because there are evidences. This one is only my lecturer who can talk about it, Dr. Fum. For him, he can fire because he is not under any contest. He's in his own contest.
I guess one of these days we have to engage doctor to deal with it for us.
Yes.
But Gani want to say thank you very much, Desmond, for the excellent and the insightful submission. From your presentation, I gathered that small-scale mines are equally required to submit a work program to be approved by the commission before they commence. So then how do they end up doing work in those manner?
So, it is a question that I always answer with the biblical dimension. You see, somebody asked, did God know that Adam and Eve would disobey him? You see, is an answer, is a question that is not easy to answer. Because God is all-knowing. But in our case, when they come with the document nicely done, you give them the permit, they will do different things. So you see, this one, I'm putting a caveat on it. It's not for political, we say. Most of the small scales, they don't want to come to the inspectorate for permit because they know that we will scrutinize them. And that is what you find a lot of them doing wrong things. The few of them that we want to put them on their toes to, they run and go and hide behind people. But like I'm saying, the time will come.
Wow.
Yeah. Small scale mining must be it's like I call them model large scale mines. It's small as it is. We must be able to do everything efficiently and in a manner just like we do it in the large scale, but in that small way. And that's why the 476 is with the necessary modification 287 to 486 applies.
It is well.
It is well.
It is well. It is well. So we get to bring this webinar to an end. We want to acknowledge, we see Engineer Stephen Yamwa Sante on. We see other mine engineers and other engineers on board. We want to acknowledge them. We say thank you for joining. I will thereby hand over to the mining engineer subdivision coordinator in the person of Engineer Frederick Edry to handle the rest.
All right, thank you very much, Desmond, and thank you. I'm supposed to give the closing remarks, so I'll go ahead and think as we conclude, and I would like to take this moment to express my appreciation to everyone involved in making this webinar a success, and to our speaker, Desmond. Thank you very much for your time, expertise, and passion. I will say it's an honor to have you with us this evening. To the organizers, also thank you for your hard work and dedication. And to all the attendees, thank you for your participation and enthusiasm and the questions and the insights. And we are glad that we could join, or you could join us. And we hope that we've all gained some valuable insight from these discussions or this webinar. And I would like to say that we need to stay tuned for more exciting events from the Chemical and Mining Division. And we look forward to seeing you again.